precious name. Amen.
Thank you very much. Member Gail, any apologies for absence?
There are no apologies, Chairman.
No apologies. All right. Morning to everyone. We have had a long break from July 27th. We're now meeting here today on October the 12th. So we have had a good summer break and we are now back to business. As I said, the last meeting on the 27th was to review and report on the Cybercrimes Act 2015, which was held on the 27th of July. The minutes of the last meeting, the summary receipt of the decisions are there. We can take the minutes at the end if people want a chance to review them further. Member Gail, you prefer to do them at the end?
Yes, Chair. I'm still trying to recap mentally from the long break.
I'm going to do that right now. Okay, so for that meeting, the technical team was asked to provide information on the following: examples of standalone provisions for cyberbullying, as well as the guidance on whether the standalone provision in Canada's Education Act was only applicable to the public school system, and whether there was examples of protections that are afforded to children generally. In respect of the proposed offense of skimmers card reader, the team from MSET, in consultation with other members of the technical team, was asked to provide the committee with further explanations on the proposed offense in order to make a decision on the recommendations. Members had difficulties in relation to the possession simpliciter, the issue of strict liability, the treatment of these items in Jamaica, what restriction, if any, are placed on them, and which of the devices are restricted and which are not. I was advised that MSET has undertaken research and will update the committee on this. Documents from the MSET that will be referenced when the matter is being discussed were circulated to members. Can you confirm whether you received those, members?
Yeah, there was a set of documents that were sent to us, I believe, on the 10th.
All right, if members can
10th
confirm and check
of
that.
July, Brandon.
So, Senator Gill, the documents were sent last week to all members.
Last week.
Yes.
All right. And the committee is to make a decision on whether to accept the proposed offenses of cyberbullying and skimmers card reader. And after deciding on the two proposed offenses, the committee is to pick up at the proposed offense by the Ministry of National Security on intentionally withholding message delivered erroneously, which is on page 10 of the general stakeholders' comments. Research findings and recommendations, part 2, Cybercrime Act 2015. So that document that was sent out last week is critical. Can we confirm that those documents were actually received and the members on the platform have them?
Documents received, Minister.
Sorry,
received, Minister.
Yeah. Received? Everybody has them?
Yes, Minister.
Yes, Chair.
All right, great. All right, so we're gonna to deal with the minutes, the confirmation and matters arising at the end. So the matter for discussion today is the continuation of the review of the Act. And that will be following on from the last. I see Minister Member Green is here also now. All right, so who is going to lead today on the continuation?
Good morning, Minister. Good morning, members.
That Kadian?
Yes, Minister. Good morning.
Morning to you. How are you?
I'm well, and
All right. So I gave a summary there. You want to just take it from there and lead
yes,
on?
Minister.
Mhm.
Yes, Minister. I thank you very much, Chairman. I will take it from there. Apologies. I knew this is the rule that you're operating in. So good morning again, Chairman, members. Following on what the Chair would have just shared, we will start with the two matters that the committee would have left off with on the last occasion. The first dealing with the issue of cyberbullying. And in relation to this matter, I'm going to yield to my colleagues from the Legal Reform Department who have been diligently looking at this matter. LRD.
Morning, everyone. So we were to take a further look back to see whether the standalone provision that was mentioned in Canada, the Education Act, whether or not that was applicable to the public school system and whether there were broader protections that were in place that were afforded to children generally. So we looked back and re-examined the matter. What we found was that the provision would be applicable not just to the public schools, but private schools as well. As for broader protections, what would apply in all of the provinces but one would be the harassment provisions, the provisions for harassment or malicious communications, which is what is utilized in most jurisdictions. There is a provision in Nova Scotia for cyberbullying and intimate images, and that legislation addresses cyberbullying by way of a commissioner who would, once there's a report made of bullying, could direct that the service provider take down the post and or also to have the user do the same. So that's the scope of it. It's not a scheme where, in this legislation, where punishment would be assigned to the offender. It's not for that purpose. It seems to be designed solely with dealing with addressing the taking down of the information in question. We also had found and had a provision in Australia. I'm just trying to get my hands on it. It's right here. In Australia, Right, where it's a similar scheme, sorry. It's under their online online safety act. It's a similar scheme whereby based on a report that may have been made, that the post in question, whatever it is that the person, whatever medium they had used, that the service provider pull it down, or the user who had posted it pull it down. So those were the two types of things that we had found in terms of specific bullying provision. Otherwise, what we found in all other jurisdictions was the use of the malicious communication provision or the harassment provision. And as for the provision under the Education Act, what it really is looking at is having the administrators, the overarching body that supervises schools, set in place procedures whereby staff is educated on what bullying is, and that they have bullying prevention plans in the schools, things like that. Again, it's not a punitive scheme to deal with bullying. I'm not sure if there were any other concerns that we could address.
It would be if it
Yeah.
is transport.
Members? You can proceed.
Okay, that is fine, Minister.
So we go to the consent, the silence is consent. All right, proceed.
Thank you very much, Chairman. With respect to the other concern, two other concerns would have been raised by the committee on the last occasion. The first concern dealt with the issue of skimmers and card readers. And in particular, the committee was asked to look back as to the technical team, I'm sorry, was asked to look at the recommendation of the major organized crime agency in relation to an offense that would make possession of skimmers and card readers possession an offense, and that without lawful excuse, or one that would make mere possession of skimmers and card readers an offense. I know that one of the things that the technical team did is that we clarified with MOCA, as indicated, that their intention was to have the possession of skimmers and card readers be a distinct offense where the person was in possession of the same without lawful excuse. And one of the things the committee asked us to look at, and I think based on the discussion that took place on the last occasion, was to determine whether this issue of lawful justification / reasonable excuse could have been contemplated to cover the concerns that were raised by MOCA, and if so, how? So one of the things that we did was that the technical team would have spoken with MOCA, and we would have had a discussion with them in relation to the legality of criminalizing possession of skimmers and card readers. And that would have led us to the documents that would have been shared with the committee, in particular, the prohibition order that was shared under the Customs Act. And that particular legislation would have identified the different types of paraphernalia that you could not import without meeting the conditions that were stipulated. That particular regulation or order, subsidiary legislation or order, would have indicated that credit card scanning equipment could not be imported into the country unless you had an import license or permit, or you had received prior approval from the minister with responsibility for national security. Based on the same, it appears to us then that for what MOCA would want, capturing the skimmers and the card readers, even that it would perhaps fall within the ambit of the credit card scanning equipment, that could be captured essentially within the ambit of the Section 10, or the proposed Section 10 legislation that we or the redrafting, I'm sorry, of Section 10. But the additional information that they would want to have captured, and in particular, magnetic strip cards, extracted credit card bin contents, as well as POS devices, those could not actually be captured under Section 10 as it is now, or even the redraft. And it's not being recommended that the committee seeks to extend it to capture these things, because as was noted by one of the members on the last occasion, we would be criminalizing possession of something or of things or of items for which there is no substantive requirement for you to have to require permission or to need permission to have those in your possession. And as such, we are of the view, and we will continue to maintain that to address the primary issue that MOCA has in relation to credit card skimmers, those will be captured under the redraft of Section 10, and any other paraphernalia that they would want to have captured, the committee could consider recommending to MOCA that MOCA speaks with the Ministry with responsibility for the Customs Act to have the order expanded to include the additional items that they would want to have captured, and because that would be the appropriate place to capture it there. And I would also share the committee that prior to making this recommendation to the committee members, the ministry had a discussion with MOCA in relation to this, and MOCA was not averse to considering having that discussion with that ministry to have the order expanded to address some of the other areas that it wanted to have addressed. And so, Chair, that would be the recommendation that we have in relation to the skimmers card readers.
Mr. Chairman, may I make a comment here?
Go ahead, sir.
I'm just wondering, with the advance of technology, whether it really makes sense to try and specify in the legislation the methods. For example, card technology is evolving now. We're it will be very few cards that will use the swipe technology. It's now all chip technology, it's tap technology, it's virtual cards. So it doesn't seem to me that we should try and go after the particular instruments of being used for fraud. No, because it's such a rapidly evolving field, and it's better we sort of go after the intent. So that was my contribution, sir.
Sounds logical to me. Let me hear from the technical people.
Thank you, Chairman, and thank you, member, for that intervention. Just to share, it was contextual, member. On the last occasion, what would have been put to the committee would have been the redrafted Section 10, which have used very generic or general language. And so I'll share it. It was the proposal is to have Section 10 read as follows: that an offense is committed if a person without lawful justification intentionally does the following: manufactures, sells, imports, distributes, discloses, or otherwise makes available, and I'm jumping over two of them to go to the third, any other data or device that is designed or adapted primarily for the purpose of committing an offense under any of Sections 3 to 9. A discussion arose because MOCA would have raised the issue in relation to prohibition for skimmers, card readers, magnetic strips, and other sort of devices. And the question then became, how could we address the concerns of MOCA for these very specific items that they were talking about, and whether they were adequately captured based on Section 10. Based on the discussion.
So you're not taking the MOCA recommended approach because these devices are so ubiquitous in e-commerce today that you have moved away from the MOCA recommendation towards more an intent based drafting of the relevant clause.
In essence, and I'm going to respond to say, in essence, what we're doing is saying that the clause as drafted addresses the concern that MOCA has at this point in time, but we were just saying that it addresses it very specifically because in relation to the skimmers and the card readers, those devices are already, you can't, if you're, for you to have a skimmer or card reader, which is credit card scanning equipment, you'd have had to have some permission to be able to have those. So if you are found with it, then one would expect that you'll be able to present the permission that would have allowed you to have it in the first place. And hence, if it is that you can't, then prosecution could take place in relation to Section 10, because you would have been a person without lawful justification who would have had a data or device that is designed or adapted primarily for, provided you are doing it to commit some offense under Sections 3 to 9. And so we're saying that would be covered. To the extent that MOCA may have desired to have other things covered, magnetic strips, for example, covered within the ambit of that particular unlawful possession, for want of a better way of expressing it, and point of sale devices, we're saying that there doesn't exist no any prohibition that would prevent someone from having these things, so that you would be able to say that the mere possession of these things would be a problem, or that you would be a person who would have it without lawful justification. And we were recommending that if MOCA desires that these particular items be considered, that the better place to do so would be in the same legislation that would currently address the issue of credit card scanning equipment. That would be the place for them to have these things addressed and to have the discussion with the Ministry of National Security. Bearing in mind, one of the things that as we contemplate prohibition of goods is the balance essentially has to be played between potential good uses of the item versus potential bad uses of the item, and whether there needs to be this restriction notwithstanding the good uses. And we are of the view that that discussion is better placed within the current regulations or orders, my apologies, that deal with that, as opposed to trying to change the scheme of what we have now under the cybercrimes legislation. So our recommendation is that the redraft of Section 10 would adequately address the concern that MOCA has at this stage, and any other equipment or device that it would wish to have a similar approach be taken to can be done under another legislation.
Chairman, through you, can you just remind us of what the insertion is with the redraft?
Sure, I'll read it again. It says, just a moment, member. So at present, Section 10 of the legislation indicates that a person commits an offense who, for the purpose of committing or facilitating the commission of an offense under any of Sections 3 to 9, that person, and I don't know, possesses, receives, manufactures, sells, imports, distributes, or discloses, or otherwise makes available a computer key or any other data or device, and we kept the context of designed or adapted primarily for the purpose of committing an offense under any of Sections 3 to 9. The redraft sort of shifts it a little bit, and it says an offense is committed if a person without lawful justification intentionally manufactures, sells, imports, distributes, discloses, or otherwise makes available, I'm jumping computer and key to state any other data or device that is designed or adapted primarily for the purpose of committing an offense under any of Sections 3 to 9. So how we have sort of shifted the approach a little bit in relation to the new Section 10 to bring the same in line with the convention. That was one of the discussions that would have taken place on the last occasion, that as it stands right now, it wasn't quite in line with the convention, and we have done it differently. And based on our assessment and also what would have been shown on the last occasion, the opinion of the DPP in relation to this particular section, we are of the view that MOCA's concerns are adequately addressed.
So the specifics in this case would be without lawful justification.
Correct.
All right, thank you.
So Chairman, if there are no other comments on
Well, Chair, just to say, I'm minded to accept the position put forward as well. I think Lady Smith has done a good job of outlining it, and it's a balance. It's a balance in that we have to strike. I do believe that based on the concerns raised, it has been adequately captured, while it may not have gone to the extent that MOCA would have wanted it to. I think it does provide sufficient ground and basis for them to act in the instances that they probably are looking to act. So I support the recommendation, Chair.
Noted. Okay, Danny, think you can proceed.
Yes, Chairman. The other concern had to do with the recommendation to make unauthorized possession of a computer program or data by an individual an offense, and a discussion arose as to whether an offense which was a possession-based offense or possession simpliciter, whether that was something that we should consider or contemplate within the ambit of the legislation. Again, this was a recommendation coming from MOCA at the time. The ministry would have done some research, and I believe that the benefit of that research was also put in the matrix for the committee's consideration. And I just wanted to share that, again, we would have had some discussion with MOCA in relation to the concerns raised by the committee and the recommendations which are here. So I'll just put it forward in this way. In relation to this particular offense, we noted that there were some jurisdictions that would have made the possession of a computer program or data an offense. Let's start off with that. 6 of those countries, however, did what we would have been recommending, which is that they would have linked this possession or data to some intention on the part of the person to use that particular data or the computer program to commit an offense or to facilitate the commission of an offense or to procure some benefit for him or herself. We noted that 3 other jurisdictions actually did not do that, that is, they didn't link it to some intention to commit an offense. However, for 2 of those jurisdictions, for one, that is Barbados, we felt that the way the Computer Misuse Act sort of constructed the provision, it was a little bit unclear as to how it would work. And with respect to Bangladesh, it also unclear as to whether or not the collection of the data was actually the unauthorized portion of the offense. Our initial recommendation, therefore, is that when we look at our redraft of Section 10, it is felt that the redraft of Section 10 can address the concern that MOCA has in some measure in relation to creating an offense that criminalizes possession of a computer program or data. And we base that on the opinion that the DPP would have shared in relation to this section. And in particular, that opinion would have noted that the possession of such information, such data or computer program could actually be treated as preparatory steps to the commission of another offense. And as such, you could prosecute that possession as a part of the preparatory steps to do something else, ostensibly because a person who is in possession of this particular sort of thing, which is the data or the program, and they have it in an unauthorized manner, would have had it in order to do something with it. And so you could actually capture the concern that MOCA had under the existing 10 as it is right now. One of the recommendations we're going to put to the committee was that we could share Section 10 as it is drafted with MOCA to get its views on whether they felt, that the redrafted or the proposed Section 10 would address its concerns. And in fact, prior to coming to the meeting, we sought to do that to avoid having to come back to the committee on this matter. In speaking with MOCA was of the view that yes, they concurred with the opinion of the Office of the DPP that the way Section 10 exists now, it's been proposed, and also the fact that the possession of these items could constitute preparatory steps, could assist it in prosecution of offenders. However, MOCA also expressed a further concern that perhaps there could be instances where it may not be as clear for that the person is about to, or is in the process of, or is going to be using the data or the program to commit an offense. And as such, the proof of the second leg could prove challenging. And additionally, MOCA expressed a concern as to whether they would have the authority, the person themselves having no authority to be in possession of this computer data or program, whether it would have the authority to even confiscate the particular item if it is that they're required to sort of prove that the possession of these things are in preparation to do something else. And so it felt, that perhaps the committee could consider still putting forward an offense that would make the possession of program or data, an unauthorized possession, of a program or data, a standalone offense. It's a matter for the committee. As I mentioned earlier, 3 jurisdictions have this. I mentioned 2 that we were not necessarily in support of the way they would have constructed it because of concerns in the construction of those provisions in those countries, but 1, that is the country of Malta. Malta does actually have something that speaks to it in terms of the approach. And I will just share I believe it's already in the matrix, but I'll share the Maltese provision very, very quickly as follows. So Malta actually, under its provision that deals with unlawful access to or use of information, provides as follows: a person who without authorization does any of the following acts shall be guilty of an offense against this article. And moving to the particular section, the act that is being spoken about is that the person takes possession of or makes use of any data, software, or supporting documentation. And so there is a provision in Malta which seeks to suggest that the part that doesn't possession of data, software, or supporting documentation rises to the level of an offense on its own. One of the things that in discussion with MOCA, we were reminded of, I should say, or assured of, is that even if, I stand to be guided by the chambers if they have a different view from MOCA on this matter, but the view is that even if it is that we have this offense, the standalone offense, it doesn't preclude the Crown from still having to prove that the possession by the individual was in fact unauthorized. And so the Crown would still have that burden of proof. And it is noted in the Maltese provision that it goes on in another subsection to say that for the purposes of this subtitle, and the subtitle here is the one that is dealing with the computer misuse. It says, for the purpose of this subtitle, a person shall be deemed to act without authorization if he is not duly authorized by an entitled person, or if he is not deemed to be an entitled person based on the nature of activities. I mentioned that to say they go on to specify essentially what unauthorized means, or the authority that one would need to have in relation to this particular section. From the standpoint of the ministry, our recommendation to the committee, as I indicated earlier, is that the existing section 10 would address the concerns of MOCA, However, if the committee is minded to consider that the requirements to sort of link preparatory steps with a further intention may hinder prosecution in this in a way that MOCA is desirous, the committee could consider a standalone offense similar to what is reflected in Malta, bearing in mind, however, that should the committee take this approach, it would be moving outside of the scheme that our Cybercrimes Act currently takes, which is a scheme which is aligned to the convention. And from our assessment of countries which have taken the approach of cybercrimes, the majority seem to align theirs with the convention, and in so doing, aligns possession of computer program and data to an intention to do something, and usually an intention to use it for the purpose of committing another offense and under the legislation. So it's a matter for the committee, but we are putting forward the position being that section 10 could assist MOCA as it is, albeit that there is a, it's based on preparatory steps, but if the committee is mandated to not accept that recommendation and to accept the recommendation of possession of data or computer programs, it would bear in mind that this will be moving outside of the current scheme that we have in relation to how we have structured this particular legislation, both prior and in large measure, even in deliberations now at the committee level. Thank you.
Chairman, you know, that's a whole lot that was said a while ago. And I'm looking at it in the scheme of an employee in an organization who either is a system developer or a programmer who would be conducting research for argument's sake. And I want to make the clear distinction between unauthorized access and the malicious intent to pursue criminal activities, because the same data can be exposed externally. And I wouldn't want the employee who is conducting the affairs as defined by his or her role to be linked with a malicious intent because an employer suggests that they had no authority to do so. And that's where I want to make the clear distinction in what is being suggested or proposed. Ms. Smith, I don't know if you understand what I'm trying to suggest.
I do understand, member, and in fact that distinction is made because the concern is in relation to the person having unauthorized possession of a program or data. So it suggests that the person would not be someone who is using it in the course of his or her employment, or would not have come into possession of the item in the course of his or her employment. And I'm very clear about that because you could be an employee working in an organization, but you are not authorized to have that particular program or data. So albeit it is company program or company information, albeit that it's in the organization, the nature of what you do does not require you to have access to that information. So the distinction that is being made is that you are unauthorized, and where you are unauthorized, then MOCA is asking that that particular possession be criminalized.
You see, we had a situation where an employee who had the authority to have access to the data, but that data was exposed to the public, unfortunately, and it may be by error. And the employee, the entity was, because of the extent of it, was considering whether or not it was maliciously done, purposely done, and was in fact considering pursuing criminal actions against the employee when it was just a flagrant error. And so I have a real concern in, you know, exposing employees who, whether authorized or unauthorized, to be, you know, to go to this nature.
Member, just to ensure, and so I understand it to be saying that while you understand the position of MOCA, you would prefer the formulation that requires the next step, that the possession of the unauthorized possession of the data or the computer program be such that it be construed in the context of preparatory steps or with an intention to do something with it.
It has to be with clear intentions, purposely and intently. Thanks, Chair.
Excuse me, Chair.
Yes, SG.
Thanks, sorry. I'm very sorry, but we, members of the chambers, have been involved in another meeting and we're just out of it. And I'm sorry that we're coming to the conversation late. So I've heard some of what has been discussed, but I just want to be clear on the proposal to amend the act. What's the proposal that's on the table that is being considered? I apologize again, sorry.
Through you, Chairman, to SG and Chambers, the ministry has no proposal to amend it. We are of the view that Section 10, as their proposal is already on the table in relation to Section 10, adequately addresses the concern that MOCA has. It's just that MOCA would have shared with us its own view that the particular formulation of Section 10, even as proposed, would not address its concern being that it would wish to be able to move to prosecute, or I'm using the word prosecution widely, prosecute persons who are in possession, unauthorized possession of a program or data, simplicity, without the need to, in any measure or manner, link it to an intention to use that data to commit or to facilitate the commission of an offense. That is the concern that MOCA would have. But as for the ministry's position, we believe that the proposed Section 10, as redrafted, would adequately address the concern that MOCA would have, and that the current Section 10, as proposed, is in line with the scheme of the cybercrimes legislation as it is now, and even in course of discussions that this committee would have had prior, it's in line with that scheme, and we would not recommend that the committee likely change the scheme in the manner that is being proposed by MOCA.
SG, you all right with that?
Yes, thank you, Chair. And I'm looking at the proposed changes that in the matrix provided, which speaks about making it an offense to receive or possess, being an offense. So I'm not sure then why MOCA, did MOCA see the proposed change?
I would have communicated the proposed change to MOCA SG. I did that, and based on our discussion, they still felt the need. They felt that it could assist, but it didn't go far enough, and that was their view at the time.
Okay, noted. Having looked at the redraft, I cannot see what the issue is, to be honest. I think that the redraft addresses the concern.
Perhaps the concern, SG, in relation to the redraft appears to tie the manufacture, sale, import, disclosure without lawful justification to the design or adaptation for the commission of an offense under sections 3 to 9. So they are still concerned about the fact, let me say it another way. And I'm going to use a redrafted provision. An offense is committed by a person without lawful justification, intentionally does any of the following: manufactures, sells, imports, distributes, discloses, or otherwise makes available any of the 3: computer, key, data, or device. Based on my discussion, it would appear that if the redraft stopped there, it would have addressed their concern, because it would have allowed them to be able to move against someone who, without lawful justification, had any of these things in their possession. But because it goes on to say, and I'm reading again, any computer, key, data, or device that is designed or adapted primarily for the purpose of committing an offense under any of sections 3 to 9, that it then requires another step to be taken, and that is the concern that they had. Wouldn't have addressed their initial view. But we are of the view, as the Chambers is, that section 10 would address the concern that they have in terms of prosecution.
Okay, I understand. I have to say I cannot support that proposal. It would be very wide. to leave the provision without the closing words. That's going to make criminals of persons who really should not be deemed or classified as criminals. I can't see the justification for not linking the opening words with the fact that these devices were designed or adapted to commit an offense under sections 3 to 9. I think that's really going very far. That's my comment, Chair.
Well, yeah, you know, your comments weigh very heavily, you know that, based on the chair that you sit in. Yeah, they are noted.
No, so Chair, it's a matter for the committee, as we had indicated earlier, the ministry supports the Chamber's view. That's our view as well. We were just sharing for full disclosure what we understood to be the concern of MOCA and how that concern could be addressed if the committee was minded with the caution that we would have put in earlier, completely supported by what the SG would have said, that we do not recommend that as the approach.
Members?
Mr. Chair,
Go ahead.
I must say that I am in agreement with these comments by the SG. She has hit the nail on the head, especially about criminalizing action.
Right.
So I just want to lend my support to her comments in general.
As I said before, that SG is the advisor to the government on legal matters, so it will be difficult not to take her advice on board. So, all right, so I guess silence is consent. Senator Campbell Rodriguez has spoken in support. So can I take it that we can move on?
Yes, Chair.
Proceed. And accepted and noted.
Okay, thank you very much, Chairman. We'll now return to the matrix, Chair. I believe on the last occasion, we were to pick up on page 10 of the matrix, the matter raised by the Ministry of National Security on intentionally withholding messages delivered in error. So the Ministry of National Security would have asked the committee to consider creating an offense similar to that which exists in Kenya's Computer Misuse and Cybercrimes Act to establish an offense for intentionally withholding messages that were delivered in error. The ministry would have opined that often victims are subject to scams and fraud schemes, and they make genuine mistakes in sending messages as well as payments to an incorrect or unintended recipient. And as currently structured, the law does not allow for the prosecution of offenders who deliberately cooperate in such instances, and I believe fail to use cooperate in such instances, and the victim is left only with the option to pursue civil suit. And I didn't go further because of the approach that we're going to take to this. So, Chair, and committee members would have recognized from the matrix that the ministry would have shared with the support, of course, of LRD as appropriate, the research findings that we had, which would have identified the construct of Section 35 of Kenya's computer misuse legislation, as well as Section 24A of the Theft Act of the United Kingdom. Section 35 of the Kenya legislation, I won't necessarily speak to that, but the Theft Act of 1968 makes a provision for the offense of dishonestly retaining a wrongful credit. And it says that a person is guilty of an offense if a wrongful credit has been made to an account kept by him or in respect of which he has any right of interest. And he goes on to explain the knowledge that the person would have in knowing that the credit was wrong and failing to take steps to ensure that the credit is cancelled. But moving from that, one of the main concern with the Ministry of National Security's recommendation to the committee is that in general, the recommendation is very, very wide. and not very specific and lacks some clarity in very key areas. And I'm going to share what the LRD would have shared in this respect, because the LRD was asked to opine on the same. And so the LRD would have made the following concern, expressed, the following concerns or raised or shared the following observations. The first being that national security has not made it clear whether the offense proposed is such that the retention of any email or message sent in error, irrespective of the nature of the message in question, should be criminalized. That's very critical. And if not, all types of messages, what types of emails or messages so sent and if not returned should constitute a criminal offense. As currently structured, the MNS's recommendation is open and is wide. We are not sure how wide they want to go or how narrow essentially it is. Thus, the inclusion of such an offense without further clarity could result in, similar to what the SG would have raised earlier, criminalization of a person, and I'm just saying similar meaning is very wide, what SG would have shared earlier. Criminalization of a person who fails to give up messages which he or she neither requested nor has even sought to use. Secondly, the construct of the MNS's recommendation may make it difficult to establish that the sending of the message or the payment was done in error. More importantly, a provision which is as wide as contemplated by MNS would simply allow someone to allege that a mail, message, or payment that was sent to a correct recipient initially is now sent to an erroneous person after having second thoughts about sending whether the payment, the message, or the email. Third, it may also be difficult to prove or to establish, that the person to whom the message or payment or email was sent actually had an intention to withhold the same. And consideration may need to be given to the fact that the retention of the message without more may not be sufficient to rise to that of an offense. It could be quite possible, depending on the nature of the email or the message in question, that the sender, notwithstanding the error made, the sender, him or herself, notwithstanding that the person would have sent it to an erroneous person, could still send the message or the email to the correct recipient without having any or suffering any sort of detriment. I'll pause there, Chairman and members, just to reiterate that whilst we understand the concern raised by MNS, the concern right now is very wide. It's as construed is very wide, and it does not allow for great clarity in relation to what exactly is to be criminalized, how it is going to be proved, and what is the damage or the harm that is going to be suffered in all instances if the matter is not, if the message or the message or the email is in fact not returned. Continuing, to establish a basis for an offense, it appears that it would have to be demonstrated that the sender, that's the person sending the message, is not in a position to resend the message to the intended recipient, either because the original message is no longer in his or her possession and now only exists in the possession of the unintended recipient, and or that the unintended recipient is able to put the message received to use that would be detrimental to the intended recipient or the sender. In this regard, the recommendation, and I would want to jump because there are also other, well, perhaps I should just go through it in detail, my apologies. Continuing, the LRD would have also shared that it has not been explained how it is that an unintended recipient would actually return the message, as it may be depending on the circumstances that he may not be able to ascertain who the sender was or who the intended recipient was, having not asked for this particular message or email to be sent to him or her. Additionally, the proposal fails to consider whether criminal liability will attach to an unintended recipient who deletes the message or data, having recognized that he or she was not the intended recipient and would not have made use of the information, made a copy, and the sender has no backup of the message. So in other words, you would have received it, you know, it's not yours, you deleted it, and therefore you're not in a position to return it as well. The committee may therefore want to consider that the approach that should be taken to addressing the concerns raised by the Minister of National Security, legitimate as they are, may exist as follows. First, the data protection legislation, depending on the type of data which actually has in fact been sent, does make provision to deal with personal data and personal data which is sent in error, and Section 61 of the law currently addresses that. Similarly, if the person who is the unintended recipient actually seeks to use the data to procure an advantage for him or herself, then under the existing Section 8 of the Cybercrimes legislation, then that person could be liable for fraud. Finally, so in other words, personal data may already be addressed under the Data Protection Act, and if the person decides to do something malicious with the information that was sent in error, existing provisions under the Cybercrimes Act already addresses the concerns. However, if the view is shared that the issues raised by the ministry well, the issue is one that would need to be addressed, and particular now focusing on the issue of erroneous payments, the committee could consider that the Ministry of National Security could recommend to the Ministry of Justice that after consultation with other stakeholders, for example, financial institutions, to determine whether our existing Larceny Act could be amended to create an offence that would be similar to the Theft Act in the UK, which speaks about dishonestly retaining wrongful credit, but also including payments that were made in error. So the recommendation is not so much in relation to the messages and the emails, but in relation to the payment portion of the MNS's proposal, and that through the appropriate minister's responsibility for that legislation, a recommendation could be made to have it amended to address the issue of retaining wrongful credit and payments. We concur with the recommendation of the LRD, that's the ministry, and I would have shared it, and also to indicate that in relation to other types of data that may have been sent in email or messages, that is adequately captured either through the Data Protection Act, where personal data is in question, or if the information is used to procure some sort of advantage for the recipient in a manner that ought not to have happened, then the person could be liable under the existing provisions of the Cybercrimes legislation. The chairman for the consideration of the committee.
Sure. Oh, I agree. Sure. I agree wholeheartedly with the position that has been taken. I don't believe that we could find this in the Act for what has been recommended by the Ministry of National Security. And I agree that if it is to be considered, probably the focus should be on the wrongful some of the wrongfully withholding credit card and debit card information, and that would be elsewhere. So I agree wholeheartedly with what has been put forward. I don't think this should be incorporated in our Act presently.
That's noted.
Thank you very much, Chairman, members. So moving next to the recommendation from the Jamaica Bankers Association, I'm now on page 22 of the matrix. I'm here, Chairman, just for clarity, because the prior sections would have dealt with the recommendation from MOCA in relation to possession simpliciter that would have started on page 15. So I'm now on page 22 of the matrix. And in respect to Jamaica Bankers Association, the recommendation really is one that would have been shared, I believe, in large measure earlier in the deliberations that the committee would have considered. And it's really that there needs to be an effective education program to ensure that the offices, the government entities that have responsibility for looking at this area could take a joined-up approach to identify the Office of the DPP, the Constabulary Force, the Financial Investigations Division, all investigating agencies, and the JDF Military Intelligence could seek to have an effective program to educate stakeholders essentially on the legislation, as well as to consider, sorry, my apologies, to have an effective program for education for with respect to the legislation. And they asked that perhaps the requirement to do so could be contemplated in any kind of regulations or guidance that could be made pursuant to the legislation when this legislation actually comes into force, the revised legislation. Just to share that the recommendations of JBA here are not recommendations which rise to the level of amendments to the legislation, and so the ministry does support the recommendation of having effective education programs which are implemented to ensure law enforcement agencies are familiar with the provisions of the Cybercrimes Act. And I believe committee members would have asked earlier that a similar matter be undertaken to ensure that stakeholders who would have raised concerns on specific sections are advised that the section as currently worded or redrafted would address their concerns. So Chairman, I don't believe that there's any matter for deliberation by the committee with respect to the recommendation from JBA.
Chairman, not only on the point of education, sir, the representation of this proposed legislation would have given all the security teams, the MOCA, the JCF, the ability to speak. And I'm suggesting that that should continue, sir. That collaboration is important, as you know, the whole question of cybercrime continues to evolve and continues to change and may be very well changing as we speak. So I'm encouraging continuous collaboration between the various critical stakeholders who would have represented these, you know, their views on these legislations, so that we don't stop talking if and when we pass the legislation, but there is continuous dialogue between the parties.
Point well taken, Member Gale. That's 100% accurate, and we know how fast the technology and everything is moving. So it's while we are doing this, things are changing as we speak.
Thank you very much, Chairman, members. Moving to the recommendation from SIMTAI about protecting critical systems. So SIMTAI recognizes, is sharing with the committee that it has some concerns that custodians of protected computers may not be aware of their responsibilities for protecting these particular computers. So they acknowledge that we have given some guidance into relation to what are protected computers, but going further to ensure that custodians understand their role is something that they're recommending for the committee's consideration. As such, SIMTAI is asking that the committee consider establishing guidelines and standards for the protection of protected computers, and that organizations with protected computers should be certified with respect to those standards, and vendors who are offering services to entities with protected computers should be subject to licensure. In relation to our assessment, that's the technical team's assessment of the recommendations from SIMTAI, we asked the committee to note that our 2015 National Cybersecurity Strategy recognizes the need for the establishment of guidelines and standards, and the need to recognizes the need for the establishment of guidelines and standards. In like fashion, this committee may recall that the Parliament passed the ICT Authority Act, which actually established a statutory body with responsibility for guiding the ICT affairs of public entities. And that particular legislation also recognizes the need for the ICT authority to establish standards and guidelines that public sector entities are going to be required to follow in relation to their IT systems and IT security. Similarly, the data protection legislation also recognizes the need for the implementation by data controllers of technical and organizational measures to protect and secure personal and sensitive personal data. And as such, we're of the view that the concerns that SIMTAI has in relation to the establishment of standards and guidelines will be addressed in some measure in the public sector through the ICT Authority Act, and that authority's responsibility to establish standards and guidelines in relation to personal data by the Data Protection Act, and the requirements for data controllers to implement technical and organizational measures as well. However, because they're speaking to protected computers, we do recognize that there could be a lacuna as well, and that the protection of, well, let me go again. Because they're dealing with protected computers, and we recognize that some of these could be within the remit of the private sector, that there in fact could be a lacuna. And as such, we're taking a recommendation one step further to indicate that some of the concerns that SIMTI has, could be addressed in companion legislation, and that the committee could consider recommending that these concerns be addressed in a companion legislation, such as a Cybersecurity Act, in which that legislation could require the following things, such as conformity to minimum standards and guidelines. That would be something that SIMTI would have raised. It could also deal with the issue of certification against standards, which is what SIMTI would have asked that organizations with protected computers should be certified against standards. And it could also address the issue of licensing of vendors who seek to offer security services to private entities. That would be more appropriate for a cybersecurity legislation rather than our Cybercrimes Act, as we're currently reviewing, and would be outside the remit of the committee. Of course, the recommendation for the promulgation of a new legislation to address cybersecurity is one that would have to meet first with cabinet approval and with the appropriate stakeholder consultation. But the committee could consider recognizing that this particular recommendation would not be addressed in the legislation before it now, but would be more appropriately addressed in other legislation subject to the approval of the cabinet in relation to the same.
Sorry, Katie, I may have missed it because I stepped away for a moment, or I may have missed it from another meeting, but we already dealt with responsible disclosure.
Member, could you guide me the page that you're on?
That is right on that is page 25. No,
I'm not on page 25 as yet, member. I'm on page 23. Okay. I'm on page 23. It's coming up next.
Good. All right.
Mr. Chair, the recommendation from SIMTI, the recommendations from SIMTI that we just looked at, I agree, are quite important. And the recommendations through Ms. Smith as to how to handle them, I also see as the logical steps, unless of course there is someone with a counter suggestion, which actually makes more sense. But based on what the information that I currently have, based on the information that I currently have, I think the recommendations are acceptable, and we should do what is necessary, especially as it relates to the companion legislation. Making the recommendation for the companion legislation.
Seems to be accepted.
Thank you very much, Chairman and members. And continuing, I'm now on, I believe, my page 25 that will flow into page 26, looking at another recommendation from SIMTI in relation to standards for assessors. It's similar to the recommendation that SIMTI would have been making earlier, which is that we need to really have in place some sort of systems that could deal with certification as well. And so SIMTI is sharing for the committee's consideration that there should be standards and guidelines to ensure that assessors and service providers of cybersecurity services for protected systems, now not just computers, wider systems, are duly qualified, and that regulations are in place to verify their claim in relation to their skill sets. In fact, they indicate that persons who do not possess the required skill sets or qualifications to provide cyber services, and if we do not have systems in place to assess their qualifications or to ensure that they're properly qualified, that such persons could in fact create challenges by making inaccurate assertions of the state of systems that they have assessed, and they may expose both the system and the organization to unmitigated risks. So therefore, they recommend certification processes to include validation of vendors, and ensuring adequate insurance to cover claims due to errors and omissions. Again, we rest on our recommendation earlier that in relation to the public sector, the ICT authority would be the appropriate authority to institute standards and guidelines that public sector entities are required to follow in relation to the protection of both protected computers and protected systems where they exist. However, we also recognize that the issue of having standards in place for persons who provide services in the cyber sector is also important. Having standards is also important. And as such, we would recommend, again, what we said earlier, which is that a Cybersecurity Act, a companion piece of legislation, may be the more appropriate place to require assessors and service providers of cybersecurity services to be duly qualified, and it could deal with the qualifications there as well. And so we would recommend for the committee's consideration that the committee, was perhaps acknowledging the importance of the recommendation by SIMTI, that the more appropriate place for this to be treated with is in a cybersecurity companion legislation rather than through the Cybercrimes Act, which is currently the remit of this committee. For your consideration, Chairman and members.
Agreed with it. I agreed with the approach, sir. It is in keeping with the other approach that we've taken for the suggestions before, and in keeping with what Senator Campbell Rodriguez had said.
Noted, Minister Green.
Chairman, I'll take us through the others. Let's go into the concern that Minister Green would have raised earlier on the issue of responsible disclosure and also raised by SIMTI. And I'm going to, Chair, with your permission, also deal with the other recommendation that SIMTI has, which is a recommendation for us to have a Cybersecurity Act. So with your permission, Chairman, I will just deal with the recommendation that SIMTI has for a Cybersecurity Act. And that recommendation is essentially that they recommend that a Cybersecurity Act be enacted that addresses, among others, a cybersecurity authority, licensing and certification, we mentioned that earlier, regulation and standards, and other areas such as international cooperation and public-private partnerships. We wanted to share with the committee that the ministry, while our research not identify many jurisdictions with a Cybersecurity Act, we noted that about 6 of them did have a cybersecurity type framework or legislation, which addressed a number of the areas that would have been raised by SIMTI in relation to a specific authority to address cybersecurity, licensure, regulation, among others. Those countries are reflected in the matrix to include Albania, Bangladesh, Ghana, Singapore, Vietnam, and the Zambia. The ministry is therefore not opposed to the recommendation. The ministry is not opposed to the recommendation made by SIMTI for the development of companion cybersecurity legislation, and wanted to share as well that in our review of the national national cybersecurity strategy by the Office of the National Security Advisor, some of the areas which SIMTI has recommended for contemplation in the new legislation are in fact being considered. And so the new cybersecurity strategy contemplates, among other things, the development of a national cybersecurity directorate or central coordinating agency with responsibility for coordinating, among other things, the national cybersecurity program, which is one of the recommendations that SIMTI has in relation to a cybersecurity authority. Additionally, the national cybersecurity strategy will also look at the development and adoption of cybersecurity technical guides for MSMEs, and the strengthening of incident reporting and response more than what we have now, as well as recommending strengthening partnerships, international partnerships, and cooperation. Some of the very things that SIMTI would have put forward. As such, Chairman, and members, Going to the recommendation from SIMTI to have a companion cybersecurity legislation, the ministry is putting forward for the committee's consideration that, again, the companion legislation can be contemplated. And in addition to that, to indicate that the current work being done on the National Cybersecurity Strategy contemplates some of the very recommendations that SIMTI has put forward in relation to how we will deal and treat with our cybersecurity framework going forward. So, Minister, Chairman, and members, the recommendation for companion legislation as put forward by SIMTI is put to yourself and the members for consideration.
Any comments, members?
Again, Chair, I support the recommendation. But is it that the responsible disclosure element would be dealt with, or is it that under this new Cybersecurity Act, or is it that we're saying there is no need for it to be incorporated because CERT already provides this sort of avenue? That was the area I was not so.
Thank you very much, Member Green. Actually, I jumped to the responsible disclosure bit. I'd asked permission to move to the Cybersecurity Act because it sort of dovetailed with the comments that were made earlier. And I will now go to the section on responsible disclosure. So both recommendations are in fact made by SIMTI, and it would have flowed behind each other. But since the second was more in keeping with the recommendations that the committee was making earlier in relation to Cybersecurity Act, I was just asking the committee to consider that recommendation first, and I'll move now to the recommendation.
Well, I supported, Chair, this companion Cybersecurity Act. I think it makes good sense. I think already SIMTI did a lot of work. I must be commended in terms of putting forward what they believe would be some of the critical provisions, especially around assessors and licensing. So I think it's definitely a direction that we should move in. And especially because I think we will have a significant advantage in providing cybersecurity resources, expertise across the region. So it would be good to put in some standards and be the forerunner in that. So I support that, Chair.
So to add on to what Minister Green has said, when we get recommendations from outside entities, especially those within the private sector that are so thorough, we need to commend them because that's part of the work of the Parliament, to receive comments and feedback that helps to make our work that much better than it would, regularly be, because there are just some things that we miss. And so I think we should really thank SIMTI and all the partners who have spent the time and done such solid research and made such recommendations that we may have overlooked. So I just wanted to add my voice to the commendations and to say that I do support all that has been recommended with regard to the recommendations from SIMTI.
Thank you, Member Rodriguez. Here, continue.
Moving now, thank you, Chairman. Moving now to the recommendation in relation to responsible disclosure. So the concern raised is that there is no framework in place to facilitate responsible disclosure of potential vulnerabilities. And therefore, how should citizens and corporations approach such a disclosure? The recommender is indicating that perhaps what could be done is that a framework could be developed, a vulnerability disclosure framework that allows individuals to safely report potential vulnerabilities. And this could be facilitated if there are clear standards for protecting computers. In assessing the recommendations in relation to responsible risk disclosure, the technical team, I recognize that at present, the Cybercrimes Act does not outline a framework for disclosure of potential vulnerabilities which have been identified by a user. That said, as indicated earlier by Member Green, It is noted that there is a vulnerability disclosure framework that exists through the Jamaica CERT, and that's the Jamaica Cyber Incident Response Team. And that particular entity facilitates the reporting of issues through its website, and this report currently can be anonymized, hence the issue of responsible disclosure and also safe reporting. It is noted, however, that there is no threat of legal action, and where the vulnerability is verified, contact is usually made with the owner of the IT resource and with the Jamaica CERT's effort, and that person's effort, aka a joint effort, is made to deal with remediation and or mitigation. In this regard, our recommendation essentially to the committee is that in relation to computers or systems which are affected by or for which there are suspected vulnerabilities, where those are systems or computers within the public sector framework, that again, the ICT Authority Act will give the ICT Authority the authority, for developing policies, standards, and guidelines that will ensure both the security, integrity, availability, and the reliability of ICT and related systems and services. So in relation to public entities, that can be addressed, or that will be addressed. In relation to the private sector, however, the recommendations of SIMTI can be incorporated through the Jamaica CERT and the framework that currently exists already, because the Jamaica CERT does take reports of vulnerabilities from the private sector and currently works with those entities to address the vulnerabilities. And as such, whilst it's not in legislation, the government does have a framework essentially that deals with disclosure of potential vulnerabilities and addressing them. Recommendation, therefore, is that there's no further need for amendment or adjustment to the cybercrimes legislation. The current framework that exists for public bodies through the ICT Authority Act is sufficient, and also through the work of JA CERT also addresses the concerns that have been raised.
I guess the one question I have, Hadian, is how have other jurisdictions dealt with this matter of responsible disclosure? Because I see the authority doesn't deal with it directly. What it says, as you have outlined, is that they can put in place a framework. It doesn't really treat it directly, and I repeat that. How have other jurisdictions dealt with this issue?
If you'd permit me, member, I will defer to Lieutenant Colonel Godfrey Sterling to perhaps provide a response on this one. Lieutenant Colonel.
No problem.
Good morning, Chair. Good morning, members. With respect to the question posed by Member Green, Chair, if you will allow, the response is that the matter of treating with responsible disclosure of vulnerabilities and breaches is dealt with differently. The most popular of which is probably the framework that is currently being used across the EU, that is published by the European Union cybersecurity apparatus, which seeks to treat with those disclosures in a very coordinated way. And so they have what they've called a coordinated vulnerability disclosure policy. And what that does is really to bring together in a single space the framework by the member states' governments within the EU, as well as to set out the responsibilities of stakeholders, including deadlines for reporting these vulnerabilities, including guidelines for coordinating the remediation, and where there is no joint remediation, the reporting of the confirmed remediation of the vulnerability or breach. And so whilst in Jamaica, we have the ability for entities and individuals to report cybersecurity breaches and or vulnerabilities to the CERT. And the ICT Authority Act will treat with the public sector entities in terms of the framework within which they will operate. That formal coordination of the private sector in a framework put forward by government is not in existence here. So that's how other jurisdictions treat with it, primarily in the European Union.
So I guess the question is, do we need to go further?
I believe it would be prudent to go further, certainly while we contemplate and take the necessary steps to enact the proposed companion legislation. What we have to start doing is to make the framework more formal and go beyond memoranda of understanding and information sharing agreements to this sort of holistic coordinated framework. And that could be a medium-term solution to what the time frame to get enacted a companion piece of legislation might be.
And again, just to be clear, in relation to the public sector, you're saying such a framework would be established through the provisions of the ICT Authority Act, yes?
That is the understanding of the provisions, member.
But has that framework been promulgated thus far?
No, the ICT. Okay, go ahead.
No, Colonel. You may go ahead. You may go ahead.
The ICT Authority Act is not yet in force, and so whilst the legislation provides for it, in practice, at this point in time, it doesn't exist.
Okay, so the present framework, if somebody wants to do a responsible disclosure, would be through JA Cert.
Yes, it would be.
Okay, I think, Chair, it's one of the areas that we have to pay special attention to. I think the reality of our present day society is that you have to have a framework which really facilitates responsible disclosure, right? And in the absence of such a framework, there may be vulnerabilities which are picked up but go unsaid until they are taken advantage of by those who do not mean well or mean us harm. So I think we have to, one, probably do some work to promote the present framework, for want of a better term, that operates through JA Cert, but additionally fast track a more formalized framework, and maybe in accordance with the EU, or looking at other best practices from across the world, so that we do have a very open framework that is well known, that applies to the public sector, that applies across the private sector. I think that's a matter of urgency.
All right. Carry on.
Thank you very much, Chairman. Thank you very much, members. If with your permission, could I move then, as we would have dealt with the issue of cybersecurity, coming from the SIMTI, the Cybersecurity Act, I will now move very quickly to the recommendations from UCHEC, reason being that the issues in relation to cybersecurity and the Ministry of Education, those would have been addressed on the last occasion, and the committee would have looked at it in large measure, or if the chair would like me to just reiterate what the Ministry of Education would have put forward, I can do that before moving on. The chair, I'm guided by you.
You can just rehash what the Minister of Education had put forward. Just summarize it.
Thank you very much, Chairman. I'll do that. So members, we may recall that the Ministry of Education would have put forward certain recommendations in relation to the treatment of children and cybersecurity, as well as other legislation that addresses nefarious activities that may take place involving children. And so the recommendation is to incorporate, the recommendation they have is to incorporate a section to deal with cybersecurity, that is the protection of internet connected systems, such as hardware, software, and data from cyber threats. They use the Zambia cyber legislation as an example because that legislation incorporates cybercrimes, cybersecurity, and child pornography material. And the review of their legislation, they argue, is very compact and clear. The ministry in our assessment notes that the legislation that we have doesn't seek to outline steps to be taken by individuals and or businesses to enable them to protect their systems, but rather focuses on cybersecurity from a law enforcement perspective, criminalizing actions that take place using computers as well as the data that comes therefrom. One of the things that we would have put forward again is that with the jurisdictions that we have identified earlier, 6 of them were identified with having cybersecurity legislation, and 3 of those 6 jurisdictions have legislation that play a dual role, both as cybersecurity and cybercrimes act. With respect to the Ghanaian legislation, that was, let me say it another way. I'm sorry, Chairman, let me go again, my apologies. So whilst there are 6 jurisdictions that were identified with cybersecurity legislation, 3 of those jurisdictions have legislation that play a dual role with both cybersecurity as well as with cyber crimes. Our recommendation, of course, is not to go that route currently, because we would have recommended that we have separate legislation to address the criminalization of activities versus cybersecurity that deals more with guidelines, standards, licensure, etc. In our own review, our review and research would have demonstrated that whilst our legislation, that is our Cybercrimes Act, doesn't seek to treat with an omnibus approach, such as that which would have been in Gambia, as well as in Ghana, we have other legislation which seeks to address the concerns which were raised by the Ministry of Education. So, for example, in relation to child pornography and the dissemination of obscene material, we have the Child Pornography Prevention Act. We have the Law Reform Fraudulent Transactions Special Provisions Act. If it is that this involves theft of identity information of children. And we also use those pieces of legislation to address offenses. These offenses, whether they occur in the cyberspace as well as on what we like to call terra firma. We would have already indicated through prior discussion on this matter, Chair, that it's not the recommendation for the cybercrimes legislation to roll up or to subsume elements of the child pornography prevention legislation. And we all have already indicated that the Law Reform Fraudulent Transactions Special Provisions Act, where applicable, would address some of the concerns that have been raised by the Ministry of Education and other stakeholders. In light of that, therefore, to the extent that the recommendations of the Ministry of Education can be captured in a cybersecurity companion legislation, and some of those concerns were already addressed, we'd recommend for the committee's consideration that they be addressed in a cybersecurity legislation rather than through the ambit of the Cybercrimes Act currently being considered now by the committee. And we will recall on the last occasion, the ministry was asked to indicate that where applicable, changes or recommendations made by recommendations for changes made by the Ministry of Education, to the extent that they fell within the remit of other entities, that the ministry be invited to share its concerns with those ministries. That was indeed done. So the ministry, the concerns of the Ministry of Education would have been appropriately addressed either earlier by the committee or certainly through the committee's approach this morning to recommend for consideration of the cabinet that companion legislation in relation to cyber security be also enacted to address some of the other concerns raised by stakeholders.
Members, I take it silence is consent. Any questions? Okay, then. You're doing well so far. There's been nothing that has been contentious.
Chairman, thank you, Chairman, and thank you, members. So we're moving now to what is on the general matrix, the final stakeholder comments. Those comments are comments coming from one of our academic institutions, University of Technology. The recommendations and or concerns raised are a bit voluminous, members, chairman and members, and so I will just move through them a bit quickly. So the University of Technology has shared some comments. So starting first with data breaches, they have expressed some concerns in relation to the cybersecurity legislation and who actually provides enforcement for data breaches. And if the breaches are borderline cybersecurity and data protection breach, who will in fact have oversight in relation to the risk. Let's continue. Also, it notes that the legislation has made provision for an information commission, and at that time, the Office of the Information Commissioner was not in place. Also, that institutions across the country do not have data protection officers to support the legal framework under the Data Protection Act, and the cybercrimes legislation has been relatively inactive. And since 2015, we have not had any new types of cybercrimes being contemplated for legislation. The UTEC goes on to explain the role of the university, its role, I'm sorry, my apologies, the role of the university in relation to the legislation, recommending that it could put forward simplification of the act, as the act is difficult to read, and that it could assist in building out an educational campaign that would support bringing the information to the attention of persons who are likely to be affected by the provisions. Additionally, UTEC is recommending that it could negotiate with the Parliament to design and promote the legislation once it is amended, and also has spoken to its cyber awareness program that it has at the university and also for the general public, indicating as well its in-house its academic programs that it has that would support further scholarship in the area of cybersecurity, even positing that it could be the place of choice for some sort of cybersecurity commissioner. They recommend other recommendations in relation to what UTEC has are there, and we just want to speak to the ones that perhaps the committee will be able to address. First, in relation to the issue of data breaches and the concern that would have been raised in relation to the same. I'll start first by indicating that data breaches that relate to personal data, as we're aware, would be addressed under the data protection legislation, and that the Office of the Information Commissioner would have oversight of the same. So when the question is raised in relation to who would have concern, who would have superintendents in relation to a breach that is borderline cybersecurity and data protection related, when it's data protection, the Information Commissioner would have responsibility. And chair and members, we would recall that in relation to the use of the unauthorized use of data by a person would be captured under this legislation. We will just to share, based on the concern that was raised by UTEC about the Office of the Information Commissioner, that the office was brought into effect on the sections of the legislation to address the Office of the Information Commissioner was brought into effect on the 1st of December last year, and the Information Commissioner was in place at that time. With respect to data protection officers, a concern was raised that the institutions do not have adequate DPOs to support the legal framework that is in place. We know that we're currently, that particular work is currently being done, and we understand essentially that members of both the legal and the ICT professions have been preparing themselves to offer data protection offer data protection officers as a service to MSMEs as well. With respect to they comment about the inactivity of the cybercrimes legislation and the fact that there have been no new types of cybercrimes since 2015, we want to remind the committee that the Office of the DPP, in fact, had indicated that in the period 2017, I'm sorry, to 2020, a total of 141 cases or offense cases that were brought under the Cybercrimes Act were disposed of a total of 233 cases that were active. And so the legislation has in fact is actually quite active and not inactive, as would have been posited by UTEC in its observations. And then in relation to new offenses, since 2015, well, the legislation would have not been under review prior to now. And as such, the committee will recall that it has deliberated on new offenses proposed for inclusion in the Cybercrimes Act as posited by various stakeholders. Moving further, with respect to the comments that the UTEC would have shared in relation to funding support to build out information security infrastructure, as well as its positions in relation to its plans for regional cybersecurity academy, etc. The ministry recommends noting their plans, but there is no further comment that we could speak to in relation to the same. And just for full disclosure, currently the ministry does house the Office of the Information Commissioner, and that arrangement is now far advanced for the Information Commissioner to be able to be housed otherwise. So with that, Chair, I do not believe that from the stakeholder comments of Universal Technology that there is any adjustment to the Cybercrimes legislation, Cybercrimes Act that is required. The committee can in fact note the comments of the ministry in relation to what was raised, where the information that we have presented appears to be different from what UTEC may have observed, and then also to note UTEC's proposals that it has to position itself to take to support the amended cybercrimes legislation going forward.
I think we agree with the observations, Chair, in terms of made by the technical team regarding the fact that the Data Protection Act and the Information Commissioner is now in place, and all the other matters raised have been deliberated on. So we agree with the approach in relation to the suggestions regarding UTEC, or from UTEC.
Noted, Minister Green. We still have to reset that meeting, especially in light of what is being discussed here.
Yeah, absolutely.
Good on.
So yes, Chairman. So Chairman and members, that brings us to the end of the matrix and the official comments of stakeholders, both in relation to very specific for the specific provisions of the legislation and also the general comments and recommendations. Chairman, I am aware, however, that there are some matters that the technical team was to return to the committee on. Some of those in relation to the Ministry of National Security. I don't believe that we have been in a position to have that meeting with the Ministry of National Security as yet, given that there would have been one other recommendation from National Security on the general stakeholders matrix. And so there, notwithstanding that we have come to the end of this matrix, there would still perhaps be a need for us to come back to the committee on any final matters that would have remained for the technical team to consider.
So that you do that at the next meeting?
Yes, Chairman. It would depend on when it's the next meeting. Perhaps you may ask for some more time to complete a review of all the outstanding matters and to come back once to the committee to conclude all of those deliberations.
All right, so the next meeting is being proposed for the 3rd of November at either 10 or 2, depending on the preference of the committee members. So I'm not sure if that would be enough time. That would be about 3 weeks away. So that is what is being proposed. Members, in terms of the time, November 3rd.
Chair, could I vote for 2 p.m. as opposed to 10?
You can propose, of course, sure.
I'm voting for 10 a.m.
Sorry, can you repeat the date, please?
November 3rd. That's a Thursday, if I'm not mistaken. Yes, Thursday, November 3rd. 10 a.m. or 2 p.m. is the two slots that are available. I hear Member Gill asking for 10 and Member Campbell for 2. So
I am good with either, Chair.
You're not being a tiebreaker.
I'm supportive.
I'm good with either, but lean towards 10.
all right.
That's just a tipping of the scale.
Member Green? Member Bunting?
Wait, the check, hold on.
I would prefer 10 o'clock, Chairman.
Member Campbell, you're not looking so good.
No, Chairman. It therefore means I will be absent because I do have a fixture in the Supreme Court that morning.
Okay. All right, anybody else has any preference? I'm actually easy.
Yeah. Thursdays on the morning is not better for me on Thursday. Sure.
All right. So we'll
It's 10
accept.
a.m.
Chairman,
Yeah.
Chairman, if I may, you'd asked me earlier just to confirm if the November 3rd, I know the members have indicated their availability as well as their availability to meet on that date. However, I was just wondering if consideration could be given to a later date in November to allow us to complete all the other matters. There is one matter that we do have which may require a bit more research that will take us beyond November the 3rd. Members may recall that UTEC would have also introduced the comment of sandbox that would have been discussed earlier, and that I think may require us to do some further deep dive with UTEC and research as well, and may also take some time for presentation. So if we could, if it's possible, be given at least another 2 weeks other than November the 3rd, we would be grateful for the additional time.
So you're asking for a November 3rd and another.
No, Chair, at least a date later than November 3rd, perhaps 2 more weeks in November, and the 3rd week in November.
Okay, all right, okay, understood.
If that could be considered.
If that is that amenable to you?
Yeah, Chair, for expediency and efficiency, and because they need the time, let's give them the time to do the research and they can put together.
I guess we'll be able to achieve. Sure. Ms. Brandon?
Yes, Chair.
You have your diary there with you? You have your...
Yes, I do. So
yeah.
Thursday in the afternoons are free, and the 22nd and the 29th at 10 a.m. is free.
All right, which
What
one?
about the 17th?
Katie, and which one you prefer, the 22nd or the 29th, to give you, to make sure that you come well prepared and to be able to get this done?
I think the team would prefer the 29th, Chairman.
29th, members? 29th at 10?
No, Mr. Chairman, 29th is not good at all for me.
Not good for me either, Chair.
Yes, that's a Tuesday. The 29th of November is no, definitely not.
Can it be the 24th, which is a Thursday? Because we have gone, the Joint Select Committee for Tobacco tends to meet more on a Tuesday. Don't know if we might schedule one that time. So I think if we could stick with the Thursdays for cybercrimes, please.
All right, so Ms. Brandon, what do you have there?
Okay, so Thursdays at 2 p.m. they're free.
Is 10 a.m. free on the 24th?
No. The Joint Select Committee on the Teaching Council Act will meet at 10 on that day.
Oh.
What? I never even knew that.
Well, the email we received asked for us to confirm, and we haven't gotten that yet. So
So I'm seeing it on the Parliament's calendar, so.
Okay.
Yeah.
I wouldn't want to hold up the committee. I may be traveling during that period, and if I am doing that, I will definitely ask for someone to chair that meeting.
Mr. Chairman, if I remember well, Ms. Smith asked for 2 weeks, and the original date was the 3rd. So the 17th couldn't work?
What dates you have between the 17th, the week of the 17th, Ms. Brandon?
Chairman, Miss Smith did indicate that there was an outstanding matter that would require time beyond the 3rd. So I think that's how we ended up going later.
Right, but she said 2 weeks, and 2 weeks from the 3rd is the 17th. So I'm asking if the 17th is available. Because we have gone 3 to 4 weeks versus the 2 weeks that she asked for.
Thursday is the 3rd. The following Thursday would be the 10th. The following Thursday would be the 17th. So it would have to be the 17th or the week thereafter.
Yes, Mr. Chair.
What you have in that week, Ms. Brandon,
So
which would be
the Tuesday, which is the 22nd, is free, Chairman. And the 24th, which is a Thursday at 2, is free also.
All right, so what's the preference? The Tuesday at 10 o'clock or the Thursday, Tuesday the 22nd at 10 or Thursday the 24th at 2, no?
Mr. Chairman, for me, the 24th at 2 would be, because I have a standing meeting on Tuesday mornings at 10.
Members, of Thursday the 24th at 2?
That works for me, Chair.
That works for me.
Okay, Chair.
All right, Thursday the 24th. Thursday the 24th at 2, and it is likely that I will be traveling, but if I am, once it's finalized, I will definitively sort and get someone to chair. And if I can join from where I am, I will for sure. All right, so Thursday the 24th at 2 p.m. is the meeting. Can we just go quickly back to...
Thank you, Chairman. Thank you, members.
Can we just go quickly back to the confirmation of the minutes on July 27th? Member Rodriguez, member Colin Campbell, I'm sure would have gone through those minutes. Can you tell me if there's any corrections or anything that needs to be?
Sure, admittedly, I did not get a chance to go through the minutes. I apologize, but I was not able to.
All right. Can I have someone who did go through those minutes and to propose and confer and second if there is no, unless you would want to do them at the next meeting to give everybody a chance?
Mr. Chair, I was going to ask if we could do them at the next meeting because I also didn't get a chance to go through them as thoroughly as I normally would.
Ms.
Well,
Brandon.
certainly we would have enough time before the next meeting, Chair.
All right, Ms. Brandon, can you just make a note in case I am not chairing that meeting, that whoever it is that needs that meeting, they put it on the agenda for me, please?
I will do, Chairman.
All right, listen, perfect timing. 11:57, great work. And we will meet again on Thursday, the 24th of November at 2 p.m., at which point I'm confident that the team will be ready to present and deal with the matters outstanding that were on the, that they're going to research and bring back the positions on. All right, until then, everybody, thank you very much. Keep safe and have a lovely afternoon.
Same to you, Chair. Thank you.
All right, Chair.
All right, everyone.
Whenever you hear the following tone, the Office of Disaster Preparedness and Emergency Management, ODPEM, will be giving information on an emergency situation affecting the island. Please be on the alert and listen to your radio and television for further information. This was a test of the emergency alert system, brought to you by ODPEM.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
I am Paula Llewellyn, Queen's Counsel, the Director of Public Prosecutions for Jamaica. We are in an era which focuses on all things technological. As such, material produced by all sorts of devices, including computers and phones, is increasingly becoming a central feature of criminal investigations. Good prosecutions are based on the fruits of good investigations. It is therefore critical that police officers who are engaged in investigations which involve the collection and examination of evidentiary material are equipped with the necessary tools which will enhance their capabilities in respect of securing the preservation of data and obtaining the production of the said data for court purposes. The Jamaican Cybercrimes Act of 2015 contains search and seizure provisions which are available and allow the police to enter any place named in the warrant to search and seize any computer material which would be reasonably required to facilitate and progress the criminal investigation.
Such computer material includes any data which may consist of video footage stored on closed-circuit surveillance systems, CCTV, or data stored on global positioning systems, GPS. Also, photographic images or any other material which may be stored electronically on any storage medium. It can also include call data records or cell site information, provided it is material which is stored electronically.
Firstly, and most importantly, police investigators must be aware that computer material cannot assist if it is not preserved at a very early stage in the criminal investigations. Preservation is critical. Computer material is transient. It can be easily deleted or rendered inaccessible to the police. Therefore, after carefully analyzing the crime scene and/or the allegations, investigators must seek to identify all items of digital evidence which may be useful in proving the commission of an offense or which may also serve to identify a suspect. Once you have identified them, you are encouraged to expeditiously seek to preserve them.
In this video, we will explore the tools given to the police under the Cybercrimes Act of 2015 to compel a citizen to preserve computer material which is reasonably required for a criminal investigation. The tools available to facilitate the production of such computer material in an intelligible form, as well as the search and seizure powers which are available to the police under the legislation.
It's a warm summer day. As young people often do, David and Wendy, who are on an afternoon stroll, decide to take a few pictures and a vlog for posting on social media. Cara, who is focused on getting to the bank on time, unwittingly walks into the vlogger's shot. These seemingly random set of events are critical to what happens next.
Miss Wendy, what happened here?
Honestly, officer, a bare thing's gone right now a while ago.
What happened?
He's a maga man, in maga bad, in about this tall, like 6 feet tall, and his face bleach out. He's a bleach out face boy.
Officer, I know so the man look, you understand? I don't know what you're talking about. In about my complexion, you understand me? And him not about 6 feet tall, him about 5'7", and him belly did big. You understand? Belly did big.
Did you identify the vehicle?
Yes, officer, yes. It's a blue Probox. Yeah, I'm gonna see the license plate number. Clear as day 5525ZZ. Clear,
No.
officer, clear.
Officer. Honest, all right? Listen, officer, you don't know nothing about car, all right? You don't know nothing, all right? It's a black Nissan Figo, all right? Not even the license plate you get right. It's 5255.